The Democratic-Republican Congress, now in power, moved to repeal the Judiciary Act of 1801. This act, they argued, was not merely inconvenient, it was an unnecessary expansion of federal power, a drain on the Treasury, and most importantly, a Federalist ploy. The repeal sailed through, effectively abolishing the 16 circuit judgeships and with them the jobs of the midnight judges. But the Federalists, though diminished, were not silent. Led by Chief Justice John Marshall, another Adams appointee, they prepared for battle. Marshall, a man of formidable intellect and an unwavering Federalist, understood the gravity of the moment. If the legislative branch could simply dissolve judgeships at will, the independence of the judiciary, a cornerstone of the Constitution, was in peril. He knew challenges would come before his court, questioning the constitutionality of the repeal. This was precisely what Jefferson and the Democratic Republicans feared. A Supreme Court ruling against the repeal would be a devastating blow, creating a constitutional crisis and potentially re-empowering the very Federalist element they had just defeated. "We cannot allow them to sit in judgment over this," Jefferson stated, his jaw tight. "Not now, not when the nation is still finding its footing after their excesses." The solution they devised was audacious, unprecedented, and deeply controversial: shut down the Supreme Court. The new Judiciary Act of 1802, while reestablishing the old circuit court structure and forcing Supreme Court justices back onto the arduous circuit riding duties as a subtle form of political pressure, included a critical provision. It altered the Supreme Court session schedule. Instead of 2 terms a year, the court would now convene only once, in February. Crucially, the previous schedule would have allowed the Supreme Court to hold a session in June 1802. The new act effectively canceled that June session and postponed any meeting of the High Court until February 1803. This meant a period of 14 months, from December 1801, when the last session ended, until February 1803, during which the Supreme Court would be silent, its doors effectively closed. The silence was deafening. Federalists cried foul, accusing the Democratic Republicans of a tyrannical power grab, of suffocating the judiciary to protect a partisan agenda. They argued that by delaying justice, the Democratic Republicans were subverting the constitutional order. They called it an unconstitutional attack on the independence of the judiciary. But for Jefferson and his allies, it was a necessary evil. This extended recess provided a critical window. It allowed the political furor over the midnight judges to cool, solidified the repeal of the 1801 Act, and, most importantly, bought them time. Time for their policies to take root. Time for public opinion to fully embrace the Democratic-Republican vision, and time to diminish the immediate threat of a Federalist-led judicial counter-revolution. When the Supreme Court finally reconvened in February 1803, the political landscape had subtly shifted. The repeal of the 1801 Act was a fait accompli, and the midnight judges were a fading memory. While the silence had been long and politically charged, it ultimately paved the way for John Marshall's brilliant, if politically astute, decision in Marbury v. Madison later that year, a decision that would affirm the court's power in a way that cleverly avoided a direct confrontation with the executive branch. The shutdown of the Supreme Court in 1802 remains a stark reminder of the intense partisan battles of the early republic and the lengths to which political actors would go to secure and consolidate power, even at the cost of temporarily sidelining a co-equal branch of government.